Let's go to this conversation now. The Commission for Conciliation, Mediation and Arbitration has ruled that the dismissal of an employee for refusing to be vaccinated against COVID-19 was substantively fair. The Commission says that she could be dismissed because she had refused to participate in the creation of a safe working environment. So how far can one go in arguing the protection of their rights where vaccine mandates are concerned? Because these are some of the arguments that she was making. Let's find out from Osborne Molatudi, a labour lawyer and founder of Molatudi Attorneys. Dr. Molatudi, thank you so much for your time. Always a pleasure to speak to you. In her arguments, the employer says she has a right to bodily and psychological integrity. She also says she felt extreme social pressure and emotional discomfort for being forced to choose between her livelihood and vaccinating. The balancing of rights is always a tricky one because no right is absolute. I wonder, in your view, if these arguments were sufficient.
Well, from the award itself, it appears that the grounds did not persuade the commissioner to rule in favor of the employee. So firstly, thank you so much for having me on your show, and good afternoon to your viewers. The balancing of rights will always be a challenging factor, and also because any adjudicator will have to assess which of these rights should be trampled upon by another right. And in this instance, we're talking about an employee's right to bodily integrity as well as freedom of choice versus the employer's right to maintain a safe and a healthy work environment in the workplace. And that's the critical aspect that will face most adjudicators insofar as this issue is concerned.
Listening to what you're saying then, can we then say that each case may be looked at in its own merit, or could we see, this particular ruling at the CCMA becoming the norm?
I doubt if it will be a norm. I think it will be prudent that each adjudicator will have to assess each case based on its own merits. In this particular instance, one reading from the award, it does appear that the employer did follow an extensive process prior to introducing the mandatory vaccination policy in its workplace, as well as engaging in various consultation over a period of 3 months, as well as making use of external attorneys to advise on the draft policy, and more importantly, even having specialists, traditional healer, a virologist, I beg your pardon, and an advisor on human rights issues to really answer any questions that may arise from the employees. So from a procedural perspective and in line with the directions issued by the Department of Employment and Labour, it would appear that the employer did everything it can prior to making vaccination compulsory in its workplaces.
The big thing she was seeking to overturn is, the permanent incapacitation, because she says that this is going to have a serious impact on her. And this is, of course, as she's making this decision to say that she's not going to get vaccinated. I wonder what permanent, incapacitation now means for her when it comes to seeking employment in the future?
Well, there are a number of factual considerations here, and one of which is the nature of the position that the employee occupied. And interestingly, her job title is something called business-related and training officer. So one would imagine that part of her responsibilities would be to interact with those that she's expected to train. And it's on that basis that the employer then identify that position to be one of those that cannot be accommodated by having the employee working from home or in an isolated place, unless, of course, if some of the training can take place virtually. So it would appear that the employer was not persuaded by her arguments, and instead, they were able to persuade the commissioner to say there was an overriding right for the employer to protect the rights of her fellow employees in the workplace due to the fact that she would be required or expected to interact with them on a daily basis. The other aspect, of course, is that the employee initially was intending to provide medical evidence that she should be exempted, but unfortunately she abandoned that aspect, and then relied on some other information. And that is why the CCMA did not really rule in her favor.
So the Labour Relations Act does recognize incapacity as a legitimate grounds for dismissal, but I'm listening to what you're saying, especially because, the ruling does say that she went to, tried going to a doctor and all of that, as you say. But I wonder, someone who does not have a job description like hers, who can argue that they don't necessarily need to be at the office in order for them to be able to do their jobs, and they can in fact work remotely. They don't need to interact with their colleagues. Can someone like that argue against being made to vaccinate?
Indeed, the directions do make provision for that. In fact, requiring employers to engage with the employees and to understand those who may refuse to be vaccinated as to why are they saying so, and whether there are any alternatives to accommodate those employees. And if they are able to provide those tangible alternatives, then the employer will be obliged to consider them and take them into consideration before terminating that employee's employment. Let's remember that incapacity means one is not able to perform his or her job due to ill health, or what is now referred to as impossibility of performance. And impossibility of performance in this instance will be due to the fact that there is scientific assessment or basis that says that if you are not vaccinated, you are not minimizing the risk of spreading COVID-19 to those around you, to your fellow colleagues, and members of the public in general. So on that basis, the employer will then be left with no choice but to take a decision that because you are refusing to be vaccinated, I'm therefore proceeding to terminate your employment for incapacity. The other option, of course, is to terminate for operational requirements. But you and I will now know that retrenchment means you can't replace the position. It means the position is redundant. So in this particular case, the employer went for incapacity because I'm sure it wishes to have a training officer going forward.
Can we see this go to the Constitutional Court for finality?
Well, the employee in this particular case was not represented by a legal representative, but she will be well advised to consider taking this matter on review to the Labour Court, and if necessary, let it go all the way to our apex court, Constitutional Court, so that at least we can have some clarity, on this contentious issue, and particularly when it comes to the balancing of rights, not only for the employees, but also for the employers, for the reasons that I've already highlighted. So yes, it is an issue that has to go all the way, no doubt about it.